The pro-Wike lawmakers' attempt to regain control of the Rivers House of Assembly will be decided tomorrow at the Court of Appeal sitting in Rivers State. The appeal court's decision is strongly awaited by Nigerians as the legal battles begin to unfold in the state. The sitting will be virtual instead of physical appearances in the courtroom. In the meantime, the Rivers State chapter of the All Progressives Congress has called for a state of emergency to be declared in the state. At a press briefing, Caretaker Committee Chairman Tony Wokocha said that the state is at war and the APC is not a part of the war. He said that crime and unrest have returned to the state following the governor's refusal to conduct local government elections.
Chairman, so to speak, as far as we are concerned, illegal council chairman, because again, who screened them? 3 assembly members. When the Supreme Court had made a decision on that matter somewhere, some time ago, when it concerns a governor in Plateau State, Supreme Court said, what one thought is, it's not about the people who are sitting, it's about the majority of members of the assembly. What we have in this state today is a situation where we have 3 assembly members. One is speaker, the other one is deputy speaker. Maybe the other one is majority leader, because there must be a majority leader to sponsor bills of government. That's what we have. Isn't that illegality? You can see that the man is thriving in illegality. So we are in trouble in the state. We are in a state of war, and because the governor is unteachable, and because the governor does not listen to counsel, even the counsel of Mr. President, APC River State that I represent today is demanding for a state of emergency in River State. It is the way out so that you and I will live in peace.
Joining us now is Professor Richard Aduche Wokocha, Associate Professor of Public Law, Rivers State University, Mkpolu, Port Harcourt. Good morning, Professor Wokocha, and welcome to the morning show.
Good morning, and good morning, Nigerians. Thanks for inviting me.
Good morning, Prof. Well, very high expectations about what the Court of Appeal is likely to come up with tomorrow on the matter of the legality or otherwise of the PDP members that defected to the APC in the House of Assembly. You have any ideas about possibilities? Let me put it like that, so that that will be safe enough. And then state of emergency that Mr. Wokocha, the interim chairman of the APC, right, in River State is talking about. Yes. Is River State ripe for a state of emergency?
Well, let's begin with the first question. What are we expecting from the Court of Appeal? We are expecting the Court of Appeal to give judgment on the issue that was brought before it. And what is that issue? It is not even a determination of what you have just said. It is a determination of whether or not it was right for the High Court to make that order restraining them from parading themselves and attempting to function as members and officers of the House of Assembly of Rivers State, their seats having been declared vacant in accordance with Section 109, subsection 2 of the Nigerian Constitution. So that is primarily what is before the court and nothing else. Remember that the High Court case is still on. What they raised this appeal against is the interim order that was made, which was later consolidated with the interlocutory order that was made after the court had both parties on the motion for restraining them from doing those things that they were doing. So that is what is before the court. The Court of Appeal is not going to talk about determine that case that is still pending at the High Court. It's not going to determine that. It's dealing with the interim order, the interlocutory order. The Court of Appeal is not going to talk about the local government issue. Local government chairmen are not parties before that court. Neither is the issue of whether local government tenure is extended or not. Neither is it an issue before the court. I suppose that when we listen to Dramatis person, the immediate past local government chairman, when we listen to them talk about what the Court of Appeal is going to say and how it's going to determine everything, they are assuming that, well, if the court says these people should continue to, their Mehule group, the appellants, should continue to do what they were doing while the case is pending at the High Court. If the court says so, then it means that all the bills, all the laws they purportedly made and amended, including the tenure elongation, will be protected. But even that, it's not an issue before the Court of Appeal, because on 20th of May, a High Court of Rivers State, presided over by Dr. Daketima Kyo Gabriel, had ruled that that amendment is unconstitutional and set it aside. So having struck it down, it does not exist. There is nothing like House of Assembly Law number 2 of 2024 made by Rivers State House of Assembly. It has been struck down for being in violation of the Constitution and Section 9 subsection 1 of the Rivers State House of Assembly, Rivers State local government law. So those are not issues that are at all before the Court of Appeal. Neither is any ruling the Court of Appeal gives tomorrow going to affect those issues.
Oh. Well, I asked you about state of emergency.
The second issue of yes, on the second issue of state of emergency, it's, when you said that, I smiled, because the only emergencies happening in Rivers State, the only likelihood of crisis, which I think has been put to control by the end of yesterday, or thereabout, end of working day yesterday, was the skirmishes that were happening at the local government secretariats. And what is the crisis? That men confront the sovereignty of Nigeria by confronting the Constitution of the Federal Republic of Nigeria, and he says such felons, or will be felons, should be considered persons who are fighting some legitimate cause. We should consider crisis to declare a state of emergency. That for me is laughable. A man sets himself against the law. He does not create crisis. There is a felon to deal with, or there is a criminal to deal with. Because when you act against the law in a manner that is prescribed for punishment under the law, the criminal code, you are committing a crime. You are engaging in some form of treason. If you take oath to public office, your term is determined. And when that term ends, it has ended. If you insist on privatizing that public office, you are committing a crime. You are contesting the space with the legitimate people who should be there. Whatever other cause you have, like legitimacy of the course of action taken by the state at the expiration of the term of your term as local government chairman, whatever questions you have, you can take to the court. But when the term for which you took out of office has elapsed, you have finished your cause. It's a public space, and it does not admit of this madness going on in Rivers State. It's a sacred space. This will be the first time I am seeing people throw themselves against the public space, against the Constitution, and insist that that should be recognized as a legal issue, that should get some attention and should be respected or something. I've heard of agreements that are contrary to the Constitution, and people are insisting that agreements should be... In what country? Where does that happen?
All right. Okay.
The public space is a sacred place. It's not a place for all manner of people, please.
It's a sacred place. And the conversation has come up a number of times. I think you've touched on it with regards to how legal these caretaker committees are. Bearing in mind that they were screened by the three-member House of Assembly, factional House of Assembly, if I could put it that way. How legal is it? Because that also is a big conversation, because they've gone to work. And then also the statements that the governor said that they can administer from anywhere. They should just start work.
The House of Assembly of a state sits wherever it resolves to sit. When we talk of the hollow chamber, it is not the building, the brick and mortar which we have built that makes it hollow chamber. It's the presence of the sovereignty of the constituencies of that territory that they represent. It's the convergence of that sovereignty that makes the place hollow. So where they are sitting is not an issue if they resolve to sit at any place. That place is the hollow chambers. Secondly, we are left with a three-man House of Assembly. That is a fact. that is the situation, it's not their fault. Neither is it the fault of Rivers State. Rivers people elected people to represent all the 23 constituencies in Rivers State. I mean, all the constituencies in Rivers State. Out of that, 32 constituencies, I think, or thereabout. Out of that, 27 people on their own, in exercise of their freedom and fundamental rights under Chapter 4 of the Constitution, elected to vacate their seats. Section 109, subsection 1G of the Constitution that applies to their case did not say it is when this happens or when that happens. It did not even say their name must be found in the register of the political party they want to enter. The law is that you are sponsored to the House. The seat you sit on belongs to a political party. That's why at the declaration of result, the party is declared to have won. Once you leave that party, you have vacated your seat. Even if you did not move to another party, there is no independent candidacy under Nigerian law. So you cannot say, I have left my party, I remain. You remain on what seat? There are no independent seats. Once that has happened, you have exercised your right. Nobody urged you to do so. You did so. The consequence of it is that you are out of the House. Subsection 2 that talks of follow-up action did not say such persons must be present when the issue is being discussed. It said the speaker or a member should raise the issue, bring it to the attention of the House, and as soon as the House confirms, then the seats are declared vacant. The only thing left that is suffering Rivers people is the follow-up action, which ought to be the conduct of election to enable those constituencies refill those spaces. But remember again, the Constitution says once the House has been convoked or has been called to action, the Constitution says the House shall have power to engage in its activities, continue with its activities, notwithstanding any vacancy. Any vacancy is any vacancy. If there was a plane crash, I mean, we don't like to talk about negative examples, but if there was a plane crash and we lost 27 members of the House of Assembly, the House will not shut down. If for some strange illness, 27 members of the House of Assembly lost capacity to continue to sit or to get up from their beds, we will not shut down the House. The House will continue, take the necessary action, and call on the necessary institutions of state to take the necessary action that will enable constituencies refill their space. So they did not make themselves three.
Okay.
27 or thereabout left the assembly, so it's not their doing, and the House remains.
Okay. So as we speak today, that case is still up for determination. All of this about the House and all of that, you know, is still up for determination. Some people have made the argument about how do you now reach a quorum in a three-man house? What should subsist? The debacle even about... Hang on a minute. The debacle even about the budget of Rivers State that was presented to this select house, and the other house are saying all of this. The debacle as regards the side-by-side sitting of the two houses in Rivers State. I'm sure if you remember Maka Igwe's production then, the Fuji House of Commotion that is going on in Rivers.
Yes.
And also the illegality, because I saw, Prof, you talked about the first side that these members, their time was already up, but you didn't talk about the illegality of the caretaker committee that Fubara swore in. The peddling of illegality also by Governor Fubara himself. Are those sacred people here?
Yes, it's important to talk about that aspect. Under the law, the House of Assembly of the state is given power to make laws determining how the local governments are to be governed. The Constitution has clearly guaranteed the existence of a local government system by democratic election. But if you check the House of Assembly law of every state in Nigeria, they make provision for appointment of a caretaker committee in the event that tenure elapses at the local government level and election has not been held. Now the Supreme Court, not today, the Supreme Court has over the years ruled in a number of cases. I remember Apan's case from Akwa Ibom State. The Supreme Court has ruled over the years that use of caretaker committee does not qualify as the government by democratic election guaranteed by the Constitution under Section 7, subsection 1. It does not qualify for that. But all those laws still retain that. You will recall that even under the last administration in Rivers State, local governments were run for about almost 3 years with caretaker committee under the immediate past administration. It is what they purported to have removed when they sat, I like to call it Committee of Friends, people, former members of the House of Assembly. When they sat after their vacation of seats to purport to have amended sections of some laws, that was what they tried to remove. It was at that time they remember Supreme Court ruled and they said that needs to go, and they purportedly removed it. But they were acting as former members of the House of Assembly who have vacated their seats, not as House of Assembly of Rivers State. So, appointment of caretaker committee is in the House of Assembly, the local government law of Rivers State, number 5 of 2018. It is still there. The Supreme Court has clarified in the past, more than 10 years now, they have consistently clarified in cases that have come up,
is the Supreme,
that does not qualify.
Which is the Supreme law? Is it not the Supreme Court judgment that is the Supreme law here?
When the Supreme Court speaks, it has defined what the law is. It means that every state ought to amend their local government laws. They ought to amend their local government laws and exactly to correspond with what the Supreme Court has said. But remember that the Supreme Court is not the National Assembly and has not made law. It defines the true position of the law.
Well,
so,
Prof,
as we speak,
Prof,
yes.
Yeah, we still have one more guest on this program, but there are some issues you have raised which I will need you to help us clarify.
Yes.
Number one, on the caretaker committees, the Supreme Court is very clear that caretaker committees are illegal.
It's clear.
We just had the Andwaka SAN, and he said that. So it's a very straightforward thing. That's number one. Number two, you were talking about the number of people who can make laws for in the House of Assembly. Section 96 of the 1999 Constitution. Just hold on, Prof.
Yes.
Section 96 of the same 1999 Constitution deals with quorum. And it says 1/3 of all the elected members in that...
1/3.
1/3, right? Now, what constitutes 1/3?
Exactly, 1/3, yes.
Yeah, what constitutes 1/3? In the light of the fact that the matter of the membership of the persons that defected has not yet been resolved. It's still in court. Number three, there was something else you referred to. Something about, I thought I wrote it down. Okay.
The ability of the House to sit, notwithstanding any vacancy?
No, I've raised the issue about quorum. I've raised the issue about... Yes, but I'll remember. But just deal with those two first, just by way of clarification.
Okay. Yes. Now, on the issue of quorum, yes, Section 96 clearly
Prof,
says...
Sorry, I've remembered.
Of the House
I've remembered. Prof, I've remembered. Sorry.
Okay.
The third one was when you were referring to Section 109, 1G. Now, there is a proviso.
Sub 1G, yes.
Yes, there's a proviso in that 109, 1G, which talks about division within the party, which was the matter in Abegunde versus Oyo State House of Assembly. Will you say that there is a division in the PDP in Rivers, resulting in the exit of those 27 aggrieved lawmakers?
In the decision referred to the Abegunde's case, Abegunde, the Supreme Court made clear what constitutes division in a party. It does not include division in a state. It does not include division in an office of the party. The Supreme Court says it has to be such division that renders the political party, incapable of being described as a political party under the law under which it was registered. For instance, it gave examples. Division in the BOT, in the NEC, and all of them in such a way that the party cannot hold a meeting. That's what the Supreme Court said. So, arguing that I have my own definition and I believe my definition is right does not stop subsection 2 of section 109 from taking place. And once subsection 2 of section 109 takes place, The remedy you are left with is to ask the court to determine that the implementation of subsection 2 was not rightly done, and the court should determine that you should come back to the house. Not that you are still in the house, you are insisting that you are still in the house. You will determine when you leave the house. No. The language of section 109 is a member vacates his seat if being a person, well, in sub 1G now, if being a person elected under the ticket of a party, he ceases to be a member of that party and becomes a member of another party. You, in the public sitting of the house, determined, and you have sworn that in affidavits before court, there is no question of whether you have left your party. If you regret it, whether you regret it or you think it was a wrong move, that is what you feel now. But you have done what the Constitution says constitutes vacating the seat. Constitution says if that happens, subsection 2 should apply. Subsection 2 has applied. If you quarrel with the number of people who are left in the house who are sitting, those are the things you will take to the court for the court to determine invalid the action taken under subsection 1, under subsection 2, so that the court can rule that you should return to the house. You cannot say you are still in the house having done what 1091 talks about. You cannot insist that you are still in the house until the court determines that action has been completed. Subsection 2 has taken place. So it's no longer a question of what constitutes, what qualifies. Those are issues for the court to determine, to enable the court to restore you if necessary.
Okay, Prof. Quorum.
So that's it 96. On that issue.
Yeah.
Yes. Now, yes, 96 talks about quorum. It says 1/3 of the house, which is correct. But I ask you a question. If by some unfortunate development we lose 27 members of the house, from the current position of the law, does it say the house must stop sitting until 27 members have been re-elected to fill those constituencies? It doesn't say so. When the Constitution talks of the house, it talks of members of the house. So if the house depletes beyond them, there is a provision that when the house meets and the member raises that quorum has not been met, the house should be suspended, the sitting should be suspended so that until when they have a quorum. That provision is there. But also compare with the provision that says the house shall sit and perform its function notwithstanding any vacancy. So is this a natural occurrence, or is this some figment of imagination of members of the house or of the public? No. People have a constitutional right to offer themselves to represent constituencies. They also have a constitutional right to decide they don't want to be there again. And when they take that action, it's no longer a problem of the house. It's something that has to be dealt with by the appropriate authority. Frustrating that with the presence or existence of court cases that have to be determined before INEC can act is suspending what INEC needs to do. But does that fall to the house? There are actions that the house prescribes specifically, the law prescribes specifically that it must be, when it says majority, it means majority of all seats, like impeachment and such actions. Other than that, majority has always meant majority of members sitting and present. Well, so finally, in the present circumstance, are we going to Yes.
Finally, Prof, in less than a minute, can we establish that there is truly a crisis in the Rivers House of Assembly? And in the purview of Section 4, should the National Assembly take over the functions of the Rivers State House of Assembly? Will you recommend that?
No, I wouldn't. The law is clear. What needs to happen when people vacate is spelled out in the law. So that cannot be called crisis. If I get up today and insist that, oh, Rivers State must do this, Nigeria must do that, that does not amount to crisis. I need to be put under the law. I need to be brought to the position of the law. That does not qualify for crisis. If this was happening when they were still in the house and it's becoming impossible for them to sit, we can talk of crisis. But they have elected to leave, and they have taken the action that constitutes that, and follow-up action completing that action has been taken.
Well, thank you very much.
So it's not a crisis.
Well, thank you very much, Professor Wokocha, for joining us on the morning show.